And let's start with the case. It's a decision of the District Court of Munich in a case where Huawei was on the claimant's side and Amazon was the defendant. The judgment was delivered in December 2023, so already a while ago. It was, however, not published until recently. I think one reason for that was that the judgment was redacted in several aspects, particularly the parts where the negotiation history of the parties had been laid down, but also, for example, the terms of the offers and counteroffers that have been exchanged have been redacted. So we don't have a lot of information on the background of the parties' discussions and how the discussions went even during litigation, the licensing discussions. But nevertheless, we can have sufficient insights on the legal reasoning of the court, and this is what we're going to present today. So again, the facts, we cannot really have a very detailed timeline here, but I think the case can be described as a usual case. There was an approach on the side of Huawei towards Amazon with a letter sent talking about the portfolio. Here, interestingly, it's a portfolio of Wi-Fi 6 patents that is the subject matter of these proceedings. So there was first contact, there was some discussions between the parties, there was an offer on Huawei's side for a licensing agreement that was not accepted by Amazon. Amazon made a counter offer. This was not accepted either. So we had the proceedings launched in 2022. Huawei filed the lawsuit before the District Court of Munich. And almost 1.5 years later, the Munich District Court delivered judgment. And the decision was very much in favor of Huawei. The court granted an injunction and other exclusionary measures, for example, the recall and the destruction of infringing products against Amazon. And this was then the judgment we're going to discuss today from December 2023. As far as we could understand, this injunction particularly was not enforced in Germany, meaning that Amazon was not obliged to take any products off the market which are Wi-Fi 6 compliant. And I think a reason for that is most likely that the parties managed to get to an agreement. So a license agreement was announced in March 2024 between Huawei and Amazon, covering the patents that are relevant here. So that means for our proceedings that there is a very low likelihood that they will go on. So this judgment we're looking at today is most likely the last judgment in this dispute. Now let's take a look at the decision of the court more in detail. The court here had, of course, primarily to examine whether there was infringement or not regarding the patent that has been asserted. The court found that there was infringement. And then the court had to deal with the defenses which Amazon raised, particularly against the claim for an injunction. And there were two defenses that were raised. The front defense, which was the most important one here and the one on which the court focused predominantly. And there was also a proportionality defense. This is basically a defense that is based on the argument that an injunction which is based on one single patent would be causing too much harm compared to the value of the patent, so that an injunction should be withheld. The court dismissed both injunctions here, both the front defense and the proportionality defense. We're going to focus on the first one, but we're also going to take a look at the proportionality considerations of the court at the end of the presentation. Now here, when it comes to the front defense, this was built on a potential abuse of market dominance. So as it is the case usually in German case law, the front defense comes from a competition law angle. The argument here is that the patent owner who has a standard essential patent has a market dominant position when it comes to licensing this specific patent. And by filing an action which could lead to the exclusion of standard compliant products from the market, he abuses this market dominant position. This is the main framework under which the front defense is dealt with in German case law. And this was the case here as well. The Munich court looked at the first question which is posed in this context, which is there a market dominant position at all? And found that Huawei holds a market dominant position. Basically, the reason for that is that there is no equivalent technical alternative available to the patent that has been asserted here. So market dominant position was confirmed. However, the court found that by filing the lawsuit, Huawei did not abuse its market dominant position. The filing of the lawsuit was not abusive initially, so when the case was launched, and in the eyes of the court, it did not become abusive during the trial based on the conduct of the parties. The reason for that was, on the one hand, that Huawei, according to the court, met the obligation that arise from its market dominant position. And on the other hand, and this is where the court placed most of its focus, Amazon had failed to be sufficiently willing towards Huawei. So this was the main reason why the court denied here that there was an abuse of a market dominant position. Before going into the willingness, the court looked at the one step before, let's say, looked at the notification of infringement. And here the court elaborated that the SEP owner has a duty to notify the infringer when the latter is potentially not aware of the unlawful use of the patents, and this duty must be done before filing an action, an infringement action. So this is not surprising. This is also not new. This comes from the Huawei versus ZTE decision of the Court of Justice of the EU, which is the basis for the SEP case law in Germany and Europe in the last almost 10 years now. What the court, however, clarified here, and I think this is interesting to keep in mind, is that apart from this duty to make a notification of infringement, further duties for the SEP owner are triggered only if the implementer is willing to take a license. This means that if the implementer is not willing to take a license, there are no further duties apart from making the notification of infringement that rest upon the SEP owner. And as we're going to see in a moment, this was something that the court believed it was the case here, so that Amazon was not willing, and therefore Huawei was under no further duty, especially a duty to make a front licensing offer to Amazon in the present proceedings. Now, the question is, what should this notification of infringement contain in terms of information in order to be considered sufficient? And the court said the standard is that the notification should identify the patent or the patents that are asserted and inform which specific act constitutes infringement. And to do that, you have to indicate the form of the infringing act and designate the infringing products. So if we want to sum it up, basically the court said that the notification should identify the patent that are infringed, the patents that are infringed, the products that infringe the patent, and also have some explanation of how infringement takes place. Now, regarding this question, the court said that you don't need to have a detailed technical or legal explanation. So you don't need to be thorough as you would be, for example, when you have an infringement action, but you have to make clear at least what is the allegation so that the implementer can check that even by assistance by an expert, for example. So here the question was, did the communications by Huawei meet this standard? And the court found that they did, so that Huawei made a sufficient notification. There was initially a letter sent which informed about the infringement of the Wi-Fi 6 portfolio by the specific products that have been subject matter of the proceedings here that have been included in the lawsuit. And there was also a further notification that followed, which included also the patent in suit. So in the eyes of the court, this meant that all necessary information had been made available to Amazon so that we had a sufficient notification. Having said that, the court then went on to examine whether Amazon had been willing or not. And here, the standard for doing that, which the court used, is a well-known standard. It comes from the decision of the Federal Court of Justice in the Sisvel Hire cases, which was delivered back in 2020. And it has these two elements, which we have discussed also in the past in our webinars. There is a formal element, if we want to call it like that, which requires a clear and unambiguous declaration of the implementer that it is prepared to sign a license on front terms. So the declaration, the clear and unambiguous declaration, the first element. And there is a second element, which is, however, equally important. After this declaration has been made, there is also required that the implementer engages in negotiations with the patent owner in a target-oriented manner. So these two elements need to be examined, need to be assessed. And as we are going to see in a moment, the court had here concerns both regarding the declarations of Amazon and, of course, also its engagement in the negotiations with Huawei. Apart from that, the court made also some further clarifications, which are in line with the case law in Germany in the last years. But I think, so we have heard this one or other time here in our webinars, but I think, again, refreshing our memory is helpful. In this respect, the court said that you need to be aware that the willingness and the request to sign a license must be continuous, meaning that it's not sufficient just to be willing after having received the notification of infringement. You need to keep on being willing as long as negotiations are active. And this is linked, of course, to this requirement to have a target-oriented engagement in the negotiations. Furthermore, the willingness cannot be subject to any conditions. So you cannot make the willingness to sign a license subject to the condition, for example, that the patents are all valid or are confirmed to be valid with a final judgment, etc. We have seen case law in Germany in the past finding that this type of declarations is not acceptable. Then the court also mentioned here that willingness is not a static element, not a static notion. What does this mean? It means that, for example, an implementer that has acted in good faith and was willing initially to take a license might change its mind and change its behavior afterwards, and nevertheless be considered unwilling if it stops negotiating with good faith at some point. And this can also run vice versa. So you can have situations where an initially unwilling implementer has a change of heart later on and engages in negotiations in an effective way. So this one would be then considered a willing licensee. And this is reflected a bit in the decision of the court here, because as we're going to see in a moment, the court examined Amazon's behavior both before the action was filed and also during the pendency of the proceedings. So again, this is the reflection that the willingness is not a static notion, it can change. What the court also clarified here is that you always need to have a case-by-case assessment. So any assessment of willingness must be made based on the specific circumstances of the case, based on the behavior of the individual parties. You cannot have here one-size-fits-all solutions. You really need to look at the specific case and how the relation between the parties went. The court then placed a lot of focus on the issue of delay, and it made clear that delaying tactics cannot be tolerated. Someone who is delaying negotiations is not a willing implementer. Interestingly, the court said that delaying tactics cannot be tolerated, on the one hand, obviously for protecting the patent owner against a holdout, but the court added here that delaying tactics cannot be tolerated also for protecting the competition among implementers. What the court basically said here is that if you have market players that have taken a license and you have one competitor who is not taking a license and delays the negotiations, and which means that it also delays payments, then this can have an effect on competition. And this is something that should not be tolerated by the courts if they have the impression or conclude that the implementer acted actually with a delaying purpose. Then the court added here, it's not only necessary to avoid delay, but on the contrary, there is a duty to promote negotiations, meaning that it's not just sufficient to discuss and talk without having any progress. If the next step is to be expected according to business practice and good faith, then this is what the implementer should also do. So it should move on with the negotiations, not just discuss, to put it very simple. But if there is a point where the next step should be taken, then this is what is to be expected. Then the court also addressed the situation of what to expect from an implementer in case there is an offer by the patent owner on the table. The question here is particularly, should the implementer react and enter into negotiations, especially if he thinks that the offer is non-front, or the court mentioned here the situation where the offer is indeed obviously non-front. Should the implementer be required to engage in negotiations anyhow? And the court said yes. So this duty is there. I mean, this goes back to the general notion that negotiations between the parties are the best way to reach front. So even if the first offer or an offer is not perfectly front, there should be negotiations based on that so that the parties can reach a front agreement at the end. This duty to react includes also a duty to raise all objections that you might have against the offer of the patent owner at once and promptly. So it is, again, part of this target-oriented engagement in negotiations, which requires from the party to really engage and try to find solutions actively. There is one big exception, however, which the court mentioned here. There is no duty to respond at all to an offer by the patent owner when this offer is absolutely unacceptable. And looking at the decision of the court here, but also some previous cases in Germany, this seems to be a rather high threshold. The offer should be so far out of a front range or so far non-front that it cannot be considered to be seriously meant. So only in this case, the court said the implementer is under no duty to react and to enter into negotiations with the patent owner. Here, this question was also touched upon by the court. We're going to see in a moment when it looked at Huawei's behavior to a certain extent. But maybe already at this point here, we can say that the court found that Huawei's offers that have been put on the table in these proceedings here were not absolutely unacceptable. So looking at all that and keeping all that in mind, the court concluded here that Amazon was unwilling. We said that already, but the court said more in detail that Amazon was unwilling both before and after the lawsuit was filed. And here, as we mentioned already, the court had concerns both regarding the declaration. So it found that at least before the proceedings, there was no clear and unconditional declaration. But the court had also concerns regarding the engagement of Amazon in the negotiations with Huawei, because it found that there was no target-oriented engagement in the negotiations. And this was both before and after the lawsuit was filed. The overall conclusion of the court was that Amazon applied delaying tactics here, with the purpose to impose its own financial license conditions on Huawei. And therefore, Amazon was, at the end of the day, unwilling. Now let's look at these elements one by one. The first one is the declaration. So we said already the court found that also a proper declaration of willingness was missing here before the litigation was launched. And how did the court examine that? It looked basically at the wording of the communications or the statements of Amazon, and it found that it had not been sufficient. For example, it found that it was not sufficient just to say that Amazon is prepared to take part in the opening of license negotiations as suggested by Huawei. So this was, in the eyes of the court, not a clear and unambiguous declaration of willingness to sign a license. So it's not a declaration of willingness to participate in negotiations. But apart from that, the court also found the, let's say, more generic statement to be willing to take a license not sufficient, because there was not an express mentioning to take a license on whatever terms are in fact found. So here the court already had found that the declaration, which was clear and unambiguous that there is an intent to sign a license, to take a license, was missing. Apart from that, the court also found that there was no target-oriented engagement in negotiations on the side of Amazon before the litigation was launched. And here the focus was placed particularly on the one counteroffer which Amazon had made. This counteroffer was made after the parties had an in-person meeting and had discussed several issues there. We're not sure how much time after this meeting Amazon made the counteroffer, because the respective part was redacted in the judgment. But in any case, the court found that this counteroffer was made too late, and it rejected two attempts of Amazon to justify this delay by basically saying you cannot justify the delay when it comes to the counteroffer here due to the fact that Amazon was allegedly lacking information. So Amazon had basically argued that they could not make the counteroffer earlier because they needed to have access to information that they did not have, and they needed to wait for that. Here the court was not convinced that this was the case, because it said, look, there was no information requested after this in-person meeting and until the counteroffer was made from Huawei. And apart from that, the court also felt that the information that was needed to make the counteroffer was already available to Amazon, so there was no reason to wait for any further information in order to make the counteroffer. And there was also another argument here that the counteroffer was delayed because Amazon had some discussions about the possibility or the ability to present a comparable license that it had signed with another SEP owner along with the counteroffer in order to, let's say, justify the numbers that were included in the counteroffer. The court was also not convinced that this was the case here, basically saying that you can make a counteroffer even without adding this third-party agreement, comparable license. It's not necessary for that. And here in the present case, the court found that it was also not necessary in terms of content, because the portfolio of the implementer of the other patent owner was not comparable to the portfolio of Huawei. Then the court looked at the behavior during the proceedings and found that Amazon had not engaged in a target-oriented manner with Huawei during the proceedings either. Here, the focus was placed on a couple of elements. One of them was a security payment that Amazon made. So Amazon, during the proceedings, provided security also in order to meet the Huawei ZTE obligations potentially. But this security payment was not sufficient in the eyes of the court to establish willingness. And the reason for that was that the court did not really recognize any impact on Amazon's position based on this security payment or security deposit, because Huawei would most likely not be able to get the money. It would still not get money for the use of their patents, which in the eyes of the court meant that it had no factual improvement in its position. On the contrary, what the court said is that it would rather be Amazon that would benefit from this security deposit, because even if there are costs for making the security deposit, at the end of the trial, because this cost would be lower than licensing fees, Amazon would be in a better financial position than if it had taken a license and had made respective royalty payments in the meantime. So again, the court found that this security deposit here was not sufficient to establish willingness on the side of Amazon, and therefore the court found no reason to withhold an injunction. Then the court also indicated that Amazon's unwillingness was established by how it was communicating, or how it had treated the possibility to get a license which would cover the patent in suit here as well by a pool. So there was in parallel a pool option which had been available for Wi-Fi 6 patents to Amazon. And in the eyes of the court, Amazon started only very late in the proceedings to really seriously discuss the possibility to take a license from the pool. And in the eyes of the court, this meant that Amazon was unwilling again. So this reluctance to make an effort to use this alternative licensing opportunity of the pool is, in the eyes of the court, a clear indication that the implementer is not willing. And here, of course, the court had not only a problem with the fact that Amazon did not engage at all, but also it saw it very critical that Amazon started engaging at a very late point in time. So here, the court would have expected that Amazon would had started negotiations eventually, or a more serious engagement with the pool if they didn't want to take a license from Huawei much earlier in the proceeding, and that could eventually then be considered in their favor. So that was the court's assessment regarding Amazon's behavior, and as we said already, the conclusion was that Amazon had not been sufficiently willing in the present case to take a license from Huawei. Having said that, the court, of course, did not need to go any further and, for example, make a final assessment of the front conformity of the licensing offers that Huawei had done. Why is that? If you remember, we said that the court recognized that if the implementer is unwilling, the patent owner is under no duty to make any other actions towards the implementer, apart, of course, from making a notification of infringement, which, as we have seen, was not an issue here. So since Huawei had no duty to make an offer, the court did not engage in a thorough and in detail assessment of the offers that it had made. However, it examined the offer to a certain extent, and this is to the extent to assess whether you could say that the offer has been absolutely unacceptable. So not whether the offer has been front, but whether it has been absolutely unacceptable. This is the question that the court raised here. And this question is not so much linked to the assessment of Huawei's conduct, because, as we said, there was no actual duty that Huawei needed to fulfill here with respect to making an offer to Amazon, but it was more linked to the standard for the assessment of the willingness of Amazon. Because, as we said, if we have an offer from the patent owner's side which is totally and absolutely unacceptable in this sense here, then the duties of the implementer to react to this offer and to engage in negotiations are different. So there are basically no duties to engage in negotiations. This would mean in our case here that the standard under which Amazon's behavior should be examined would be a different one. So this question of whether the offer was absolutely unacceptable or not would play a role in the present proceedings. Again, not regarding so much Huawei's part, but regarding the extent of the obligations of Amazon. And here the court, as I said already, found that the license offers of Huawei were not absolutely unacceptable. On the contrary, the court believed that they were a suitable starting point for negotiations between willing parties. And one reason for that was that the terms offered to Amazon were aligned with license agreements signed with comparable competitors which Huawei had presented. So this was here just to clarify which was the extent of the examination of the court regarding the ACP offers, the ACP owners offer, the Huawei's offers here. It was not a final assessment that the offers were front. That's just to keep in mind, but it was rather the assessment that they were not absolutely unacceptable, which meant that there were a sufficient basis for negotiations, which, as we have seen, did not take place at the end of the day because Amazon did not act sufficiently willing to do that. Nevertheless, the court touched upon some elements which I think are interesting for us to have a look at. So the question is, of course, here also regarding the standard, which is the basis for making this assessment here. And the court said the basis for the assessment of whether the offer had been absolutely unacceptable or not should primarily be the licensing concept of the SEP owner as it is established in the market, for example, through agreements that have been signed. So this is where you should start, basically. This is the basis, the licensing concept of the SEP owner. Why is that? A very practical reason, according to the court, supports this conclusion. If you have agreements signed in the market for a specific portfolio, then this is a factual presumption that the terms offered are reasonable since they have been accepted in the market and also mirror the value of the patent or the portfolio that's licensed. Because exactly they have been accepted in the market through several agreements that have been signed. So that's the reason why you should use this as a reference point, the licensing concept of the SEP owner. Another reason, of course, is that the SEP owner, according to the court here, cannot deviate from this licensing practice without, let's say, justification. So it's only possible if the cases between the parties are very different. But other than that, deviations are not allowed. So this licensing concept or the laxer licensing practice really gives the framework to measure whether a specific offer is acceptable or not. Regarding the specific question, how far should you go in such constellations as we have here, where you have a assertion of a patent and you have a front defense raised against that? How far should you go with examining the pricing of the patent owner? The court said you should not do that in a context of a front defense in too much detail. So, of course, you need to have some thoughts about that. But again, we're not talking about a final assessment of the front conformity. It should not be done in too much detail in the eyes of the court. So this means, for example, that if you have differences in the pricing, especially differences regarding what the parties had described here in the proceedings as the effective license fee, which is, let's say, the amount payable after you unpack lump sum agreements. If you have differences there between contracts that are already signed and the offer to the implementer, the specific implementer in the proceedings, then these differences that do not really cause discrimination in any scenario. That was one statement of the court here. So if you want to argue basically that an offer has been non-front because it is discriminating, it's not sufficient just to argue that there are differences in this effective license fee with already existing agreements. There is a higher threshold here. The court mentioned that discrimination is only given when comparable competitors are granted favorable condition to a non-negligible extent, which means, of course, if we read it otherwise, to a sufficient to a significant extent. So, not any difference in pricing is discriminatory. You have to have favorable conditions to comparable competitors, which go above a certain thresholds, which are significant. And in the eyes of the court, this was not the case here. What the court added here, and I think this is again something interesting for us to keep in mind, is that if the argument is exactly what we mentioned before, that the implementer complains that its competitors got a better deal or got more favorable terms, then the court said, and it's not the first time, we have seen this in other decisions coming from Munich in the past, if you want to be arguing that you are being discriminated against and that your competitors have gotten a better deal, then to be considered willing, you must be prepared to take a license at least at the same allegedly better conditions of your competitors. So if you don't do that, then this argument really does not have any feet, and it does not help you. On the contrary, it might be used against you in the sense that it might be an indication of unwillingness. So this is something here to keep in mind in this context when it comes to pricing and potential arguments which are linked to a discrimination, price discrimination, etc. In the present proceedings here, looking at the two agreements that I think it was two agreements that Huawei had presented, the court identified some differences compared to the offers made to Amazon, but it did not consider that these differences were arbitrary, meaning that there was no justification for these differences. And one reason which the court referred to say that there could be justification for these differences is that the agreements that have been produced by Huawei and had been signed with other licensees had been signed without litigation. So here the court basically said that you cannot directly compare agreements that were signed without litigations with agreements that have been signed after the parties have litigated. And then basically argue that there is a difference in the price, and this difference constitutes discrimination, which makes the offer non-front. There is a difference in the eyes of the court between agreements that have been signed with litigation and those that have been signed without litigation. Then finally, the court also discussed a couple of other points which are linked to pricing again. There was a particular argument of how much should the Wi-Fi 6 standard cost, because this is the latest standard, the newest standard that is available for Wi-Fi. And here the argument was, why should the Wi-Fi 6 standards cost more, have higher licensing fees compared to the previous standard generations, if you take into account particularly that the chipsets, for example, or devices that are Wi-Fi 6 standard compliant are not more expensive, or the price remains stable. So the argument was, if you pay the same thing for Wi-Fi 5 products and Wi-Fi 6 products, why should the fees for Wi-Fi 6 be higher? Or more concrete, the argument was they should not be higher, since we have the same price basically for the standard compliant products. The court rejected this notion and found that it's generally not harmful that Wi-Fi 6 license fees are higher than fees for previous standard generations. And it did so by having, let's say, a general concern, saying that generally the comparison between the standard, the newest standard with previous standard generations is no suitable criterion for value determination. So you cannot determine the value of a standard generation compared to the value of previous standard generations. This is not a valid way to make a value determination and determine also the license fees that are due for every standard generation. So this was here one point which the court made. And then there seemed to be some arguments also regarding what would be the impact of potentially higher licensing fees for Wi-Fi 6 on the consumers, and on whether the consumers would be able to pay or willing to pay more for Wi-Fi 6 products compared to Wi-Fi 5 and the previous Wi-Fi generations. But the court said at the end of the day, this in the present case was an irrelevant question, whether consumers are prepared to pay more for Wi-Fi 6 or not, particularly because the parties failed to show that higher licensing fees for Wi-Fi 6 would also raise the end product's prices. So here, again, the court did not find this to be convincing. At least it did not find that convincing facts or sufficient facts were presented in the proceeding to support this notion. So at the end of the day, the conclusion of the court was that all of these concerns, all of these arguments that have been expressed against the offers of Huawei did not raise up to a level where you could say that the offer was absolutely unacceptable, was absolutely not front, and could not be a basis for any negotiations. There could be things to consider, things to discuss, but nevertheless, it was something, these were offers that were within the range and did not really change anything in the way Amazon should have reacted to them and should have behaved towards Huawei, especially the way Amazon should have engaged in negotiations regarding these offers. So this was the court's analysis regarding the first defense that was raised against the claims here, the front defense. And then the court also turned to also examine the proportionality defense. I mentioned that in the beginning a bit already, but maybe here a little bit more explanation of what this is about. This proportionality issue is something which is, of course, not linked only to patents, not linked only to SEPs. It is part of a broader debate. It's a general principle of law, also in Germany, of civil law as well, which might limit the exercise of specific rights if they go, let's say, above a specific level, and the harm that they might cause would be disproportionate to the value of the right and the need to protect the right. With regards to patents, this had been a large debate in Germany of whether you need to have a provision specifically limiting injunctions based on proportionality considerations in the law, etc. This ended up in 2021 with a reform of the Patent Act, of the German Patent Act, which included a specific provision covering all potential patents, not only SEPs, stipulating that in very exceptional circumstances, proportionality could indeed play a role, and you could say that the patent is not going to be enforced, or it's not going to be temporarily enforced. You can, for example, give a transition period to the implementer and infringer to change, to make a workaround, etc., if proportionality is not observed. And the question that has been posed after that is what is the use of this proportionality defense in SEP-related cases? Because here we will have, as it is usually the case, a front defense, and the question is, what is the relation between the front defense and this additional, eventually, defense based on proportionality grounds? The court found that in the present proceedings, this defense cannot be successful. It dismissed this defense and made a general comment that regarding this relation, exactly what we mentioned already between the front defense and the defense based on proportionality, that proportionality is not available as a defense if a front defense can be raised in the proceedings. So as a rule, if a front defense is available, and this would be most of the times the case when we have SEPs asserted or front committed patents asserted, then proportionality defense is not available on top of that, in addition to the front defense, unless extraordinary circumstances exist. So unless you have extraordinary circumstances, reasons why you should examine proportionality on top of a front defense. These extraordinary circumstances were not really there in the present case, so that's why the court did not really go through with a proportionality defense in the present proceedings. What the court mentioned, on the contrary, and this was something he did with an eye on Amazon's behavior here, was that if you have an unwilling implementer who raises then the proportionality defense in the proceedings, then this implementer acts in bad faith. So the court said here, basically, if you have someone who has refused to take a license, who has refused to negotiate and was not willing to negotiate in good faith, and in the proceedings then tries to avoid an injunction by saying that the patent enforcement of the specific patent would be disproportionate, then this is something that acts in bad faith and cannot have any standing before the court. It cannot really change the decision of the court to grant an injunction and other exclusionary measures. Here, having said that, the court specifically also dismissed the ask of Amazon to have a transition period, which again would be a period in time in which the injunction that would be granted by the court would not be enforced. This could be, for example, I don't know, 5 months or 6 months or something like that. So an injunction would be granted. It would not be withheld, but it would not be enforceable for a period of time, which would allow Amazon to stop infringement without needing to, let's say, cease operations in Germany. But the court found that this was not justified in the present case. So even not only withholding an injunction totally, but also granting a transition period was not justified, because Amazon had sufficient time after the infringement notice to sign a license, and it did not do so. So even this, let's say, partly blocking the enforcement for a specific period of time was not found to be acceptable by the court in the present case under the present circumstances.